Hello, Professor Qureshi. Welcome. Hello hocam. Hoş geldiniz.
Hoş bulduk. Good afternoon.
Good afternoon. Professor Qureshi, I think it's still mute.
Yep. Yes. Assalamu alaikum. How are you? Good afternoon, everybody.
Thank you. Good afternoon, brother. Welcome. It's just a few minutes passing 2. Is it okay to start, hocam? Professor Qureshi?
In your hands entirely.
Okay.
And by me, yes.
Okay, thank you. Welcome you all. Good afternoon, everybody. We can start the program. I salute you all on behalf of Istanbul Arbitration Center. We are really happy to be with you with another hot topic in arbitration. Today we have two very experienced lawyers with us, and Professor Dr. Ziya Akıncı and Professor Khawar Qureshi. Both of them are really well-known names in arbitration and in international law, and both of them have acted as counsel and as arbitrator in many domestic and international arbitration cases. As you know, we involve with arbitration mainly either as counsel or arbitrators, occasionally as witness or legal experts. And from these positions, we have our own expectations as arbitrator or as counsel whenever we are involved with arbitration. When we sit on the arbitration table with the head of an arbitrator, I mean as arbitrator, we expect to solve the dispute smoothly, as quickly as possible without any problems. On the other hand, while we are a counsel or acting as a counsel, we sit on the table, then everything changes. We just want to win the case, our client's case, and earn the attorney fee that we agreed with the client. Today, our two very well experienced arbitration experts are going to talk about the expectations of both heads, I mean both positions. Firstly, the president of ISTAC, Professor Ziya Akıncı, will talk about the expectations of an arbitrator from the counsel in arbitration. Secondly, Professor Qureshi is going to talk about from the other side of the table. I mean, as the counsel, what a counsel expects from arbitration. Please write your questions in the Q&A section, and the Turkish questions will be, the program is also on YouTube for Turkish listeners. The program is going to be translated into Turkish simultaneously. We will take the Turkish questions from YouTube and translate into English. So for those who listens to the program in English, has to go to interpretation section on the bottom of the right-hand side. Please go there and choose English channel for the Turkish questions. Not now, but when the Turkish questions are read out. Now, as I said, we will start with the Professor Ziya Akıncı, Professor Dr. Ziya Akıncı. But for these programs, we all know that firstly we have to talk about who the speaker is. Professor Akıncı is the president of Istanbul Arbitration Center, a member of the Istanbul Bar Association, and the chairman of the International Private Law Department of Galatasaray University. And he has been recognized by legal advisors and legal directories as a leading individual in arbitration, dispute resolution, international commercial law, and construction. He is also the managing partner of Akıncı Law Firm based in Istanbul. Professor Akıncı has been involved in a large number of domestic and international disputes as arbitrator, counsel, and legal expert, and has acted under several arbitration rules, including ICSID, Ancestral, ICC, LCIA, SCC, DIAC, TRAC, and ITOTAN. Professor Akıncı worked on projects and disputes for highways, railways, metro buildings, underground sewerage system, infrastructure, civil projects, or so, and in many different jurisdictions in Turkey and also in many countries worldwide, involving Europe, Middle East, and CIS countries. He is also a fellow of Chartered Arbitration Institute, and he is the author of numerous books and publications, including International Arbitration, International Construction Contracts, and Transportation Law. He also teaches international arbitration, international investment, and international private law. Floor is yours, hocam.
Thank you very much Yasin Bey. Çok teşekkür ederim. Bütün dinleyicilere sevgi ve saygılarımı sunuyorum. In fact, we arranged this conference in both languages, both Turkish and English. But for technical reason, I am supposed to give my speech in English, apparently. That was a surprise for me, last minute surprise. I'm going to improvise. But in any case, I'm sorry, I cannot, for the technical reason, I should speak in English. I apologize for our Turkish listener. But in any case, it is a great pleasure to join in another Young ISTAC activity. I'm sure many of you knows how much the Young ISTAC means for us. All their activities are really very precious for us. We are very proud of our Young ISTAC because it is a great hope, great promise for us that we can feel a new arbitration generation is coming in Turkey. We are very happy, and this kind of events, international events, are also very important because we know Young ISTAC has quite a good amount of members in abroad as well. Another pleasure and honor is to be a co-speaker together with Mr. Qureshi. He is a world-class, excellent and experienced lawyer, but more importantly, an excellent friend for Turkey, and if I may say so, for myself as well. So we are very grateful and very happy to have Mr. Qureshi in this event as well. Well, the heading of the conference is really very impressive. Experience is talking. That makes us under pressure and a little bit embarrassed, but I personally am very happy to share my humble experience with especially young fellows as being an arbitrator. What would an arbitrator expect from the council? I hope our experiences would be something useful for the participants. Well, we have to accept in an arbitration, arbitrator and the council have different roles and different targets. They have different role and different targets, but at the same time, they have lots of things in common. So I'm going to try to analyze in the eye of the arbitrator what an arbitrator would expect and how a council can benefit from this approach. Well, first of all, before we start, one should not forget that most of the arbitrators, if not all of them, are experienced counsels. So in fact, arbitrators and counsel are not very different from each other. All arbitrators used to be or still they are counsel at the same time, like myself or Mr. Qureshi. We are nominated, we are appointed as an arbitrator, and quite often we act as counsel. So we know each other, we understand each other, and as a counsel, when you address the arbitrator or when you conduct the arbitration, you should not forget that in fact the arbitrator is a counsel or used to be a counsel. That may make life easier to understand each other and to be open to each other because we know each other, if I may say so. In a very nutshell, an arbitrator would have two targets. And in other words, the arbitrator would be interested basically two main points. The first one is to have a fair decision on the merit. And the second main target would be a fair procedure until the end of the arbitration. So that is the two most important points in arbitrator's mind. And of course, arbitrator would like the life easier and safer for himself or herself all the time. But basically, those two parameters is fair decision on the merit and a fair procedure, that means due process during the conduct of the arbitration. Let's start with the fair procedure. In other words, the issues, let's start with the merit. The issues related to the merit, I would like to talk about. Well, when we talk about the merit, in fact, everything is in counsel's hand from the beginning until the end. Basically, parties present the facts, the evidence, the legal arguments to convince the arbitrator. That is what we call arbitration for. So, starting with the facts, the parties present facts in a most efficient way to convince the arbitrator. When you are a counsel, you need to concentrate that. You need to present your facts in a most efficient way, most convincing way to tell your story. In fact, when we talk about the facts, we are talking about your story. You need to explain your story. How can you do it? There may be different kind of method. For example, very traditionally, you can have a chronological order of the facts. You can explain this happened and then this happened, etc. Or you can classify the facts and then have a group of the facts. And by doing so, you can try to explain your story and convince the arbitrator about your story by explaining these facts. In any way, the more understandable your facts and story is, the more convincing it will be for the arbitrator. Because if the arbitrator correctly understands the facts, either in a chronological way or classifying, grouping all the facts, you need to tell your story as clear as possible. Feel free to use headings. They are very useful to follow up, and this is very user-friendly, of course. But the most important point is, by presenting the facts, in fact, you are telling your story, and while you are telling your story, you want to convince the arbitrator. So therefore, your submission should be clear enough. In international arbitration, most of the time, the language of the arbitration is English, and most of the time, the participant, that means counsels and arbitrators, are not native speakers. So you should always remember this. Instead of having Shakespeare-style long sentences, make it as short, clear, but understandable as possible. This is very important. Remember, most of the time, the counsel and arbitrators are not native speakers. So the most important point is to express yourself correctly and user-friendly way. And when you explain your story, that means when you are stating the facts, try to refer to the evidences as often as possible. Because when the arbitrator reads your submission, it shouldn't be only your interpretation or only your word. You need to use the evidences as efficient as possible. So immediately when the arbitrator learn about the facts, the arbitrator should know there are evidences to prove this. That will make your story, your facts, of course, more convincing. Another issue when we talk about merit is, of course, the legal arguments. Especially in the Turkish court proceeding, you can be more relaxed about legal arguments, because in many civil law countries, like in Turkey, one of the fundamental principles is the judge apply and knows the law ex officio. So therefore, even if you don't state the law very correctly, then the judge has the authority and duty to apply the law correctly and then make the decision. However, this is not exactly what it is in arbitration, because in arbitration, you need to explain the legal grounds as clear as possible. You need to show which legal argument you are relying on. That also includes the contractual arguments as well, of course. But one of the especially recent and widely accepted principle in arbitration is people don't want surprise decisions. So you don't talk about any legal issue, but suddenly the arbitrator say, oh, we know the law very well now, this is our legal grounds. Even if the arbitrators do so, the award can be cancelled. There are civil court decisions saying that, look, these legal arguments had not been discussed, so therefore the due process was violated and they canceled the award. So therefore, unlike the state courts in Turkey, you need to explain your legal grounds as clear as possible, and you need to state which legal arguments you are relying on. If it is local law that the arbitral tribunal is not very familiar, you can refer to legal expert or, of course, the other sources. But please always be aware that you have the duty to explain the legal arguments as well. Another point is, time to time, arbitrators may ask questions to the parties, either in during the hearing or sometimes after hearing or before hearing. The arbitrators can give some question to the parties. You need to be very careful about it, because in fact, those are the points that the arbitrators are interested. So you should explain and answer these questions as clear as possible, because obviously they are interested in these points and they want you to talk about these points. So therefore, as much as your submission, answering to arbitrators' questions are also very important. Sometimes it may not be easy to understand what is in arbitrator's mind, because the questions may not be very clear, or you would feel very nervous. What should I say? If I say so, maybe it may fire back, etc. If necessary, you can ask clarification. But remember, if arbitrators ask some questions, there should be a reason to do so. So therefore, you need to focus on these questions and explain the issues related to merit according to the arbitrator's questions. Another important issue is evidences, written evidences. Again, you need to present your evidences as convenient as possible. Remember, you are trying to convince the arbitrator. normally in practice, arbitrators have a very famous PO1, Procedural Order 1. In this first procedural order, the arbitrators explain what kind of procedural orders they are expecting to follow the parties. And most of the time they talk about presentation of the evidences, when to present the evidences, how to present the evidences, which format, etc. You need to very carefully follow Procedural Order 1. Even when this Procedural Order 1 is being agreed or presented to you, you need to express your comments if necessary, or you need to ask for clarification, because those are the rules that you are going to follow during the arbitration. So therefore, presentation of the written evidence is also very important. Remember, these days, everything is online, including the submissions. So therefore, these days, it is very convenient to utilize hyperlink. And when you read, when the arbitrator reads the statement, you know, there is an argument, and suddenly there is a lovely blue evidence number. You just touch it, and suddenly the evidence comes to you. It's so convenient. So again, as a counsel, it is your duty to make life as easy as possible for the arbitrator, so that you can convince the arbitrator can very easily consider, take account the evidences that you are presenting. So presenting the written evidences is also important. Expert reports. This is another delicate issue, especially for the Turkish practitioner, because in many litigation, or in all litigation almost in Turkey, we have experts. But the way the expert witness is completely different than our court practice, because in our court practice, the court ex officio appoint the expert, and the expert write the report, and then you give a comment. That is not how it works in international arbitration. If not all the time, most of the time, the parties present independent expert opinion to the arbitrators. I mean, I experience sometimes Turkish parties do not present any expert witness opinion to the arbitrators. They expect arbitrators to appoint experts. Unfortunately, this is not the case. If you miss the opportunity to present expert opinion, then it will be too late. So therefore, be careful. Expert witness practice is completely different than court practice in Turkey. You are going to present an expert opinion, but remember, it is going to be, again, independent expert opinion. Because your client is going to pay the bill of the expert, it doesn't mean that this expert opinion will be advocating your client case. The expert has to be independent, because they are going to be cross-examined during the arbitration. So therefore, you should know what you are doing when you get expert opinion. Another point is, in international arbitration, substantiation of the quantum is very important. In court practice, you can simply throw a figure, and then because the court is going to appoint an expert, the expert is going to check the invoices, the commercial books, etc., and then there is going to be a figure. It is not going to work like this in international arbitration, because in international arbitration, if you are claiming an amount, you need to substantiate it. You need to prove this amount. So therefore, remember, for each invoice, for each figure, you have to prove, you have to have evidence, and you have to substantiate it. The merit issues, besides the merit issues, let me talk about some procedural issues as well, because as we discussed at the beginning of the speech, there are two important points in arbitrator's mind. The first one is having a fair decision on merit, and the second one is having a fair procedure, due process should be respected all the time. So therefore, due process is a very delicate issue for an arbitrator. It is like a Damocles' sword above the arbitrator's head. So therefore, you may observe that arbitrator always try to have the balance and care about due process very intensively. Well, first of all, at the beginning of the arbitration, most probably terms of reference is going to be drafted. Sometimes the parties unnecessarily object terms of reference, especially the other party draft its claims or defenses, etc. I mean, it is so unnecessary. Let each party express their part of the claims and defenses, and then you don't need to do anything with the other parties. If they want to express their position in another way, don't interfere. So always try to remember you need to cooperate with arbitrators, and if not necessary, do not object every minor points. To be frank, the arbitrators would not be very happy if you give so many comments, so many objections. Of course, if necessary, you can, but if not, everybody should make everybody's life as easy as possible. Provisional timetable is a delicate issue to finalize because the lawyers are very busy, arbitrators, counsels. But then when you agree, or while you are agreeing procedural timetable, you need to be constructive, and you should not delay the procedural timetable. And when it is agreed, try to follow it, especially if any counsel, I mean, the counsel may ask time extension. It is quite understandable, but any request for time extension, changing the date of the hearing is a big issue. Be careful with it. The arbitrators would not be happy about it because the arbitrators are very busy, and finding a whole new week to have another arbitration hearing date would be very difficult. It may cause 1 year delay sometimes, depending on the availability of the arbitrators. In general, try to agree with the opposing counsel as much as possible. If you can agree, the arbitrators would be happy generally. They may give some comments, but if the parties are happy, the arbitrators would be even happier. So therefore, try to agree as much as possible with the opposing counsel. Opposing counsels are not your enemy, of course, and you can make life easier by agreeing on at least small points by points. But of course, if there are some issues you cannot agree, then you can ask the arbitrators to make a decision. At every stage, you need to be gentle to your opposing counsel. I mean, it is a kind of personality, but sometimes I observe some counsels very, very aggressive, not to the other party, but to the other counsel. This is very wrong. At the end of the day, we are all professionals, and we need to respect and support each other. As they say, be gentle and kick the ball, not the man. So I think cooperation is very important at every stage. New claims are always unpleasant, but I have to say very often new claims are accepted, because the other alternative of new claims is starting a new arbitration. That is not convenient for anybody. But if you are going to have a new claim, it should not be too late. If it is a violation of good faith, of course, the arbitrators may forbidden it. Unsolicited submissions or evidences are another delicate issue that arbitrators may not be very happy. Unfortunately, in Turkish arbitration practice, I experienced that without any schedule, suddenly one of the counsel file a new unsolicited submission, and the opposing the opposing counsel has to answer, suddenly you may have a tsunami of the submissions, because the one there is answer stated submission, the other responded. This is very important. Don't do it, and if you are going to do it, make an application first, get a permit from the tribunal, and then after explaining why you need unsolicited submission, you can file a new submission or evidence when necessary. Of course, the guerrilla tactics is another subject that we need to mention at least. It is the fact, unfortunately, in some cases we have guerrilla tactics to delay arbitration or to increase the expenses. But remember, the arbitrators are experienced counsels and they know what you are doing. And as soon as you start this kind of guerrilla tactics, the understands may have an idea that, look, this case, this party doesn't have any case, so therefore they are trying to delay the arbitration or make the cost increase, etc. So there may be a negative prejudice against your client if you utilize this kind of guerrilla tactics. And the arbitrators may consider this when they award about the cost of the arbitration. This may be also another consequence. And parallel litigation, again, we experience this time to time, especially for the post-M&A arbitration. Suddenly there may be a number of cases related to the same subject, even if it is not the same subject. Arbitrators may have the power of anti-suit injunction, but at the end of the day, again, it may be considered as part of the guerrilla tactic. And if not necessary, instead, you focus on the merit in arbitration, and by doing so, the arbitrators may have a better idea on your case and on your claimant. Document production, sometimes very useful, but again, parties should be reasonable about it. In one of my exit cases, I experienced that the document production document, red fan schedule as they call, was more than 900 pages. Can you imagine? I mean, so many hours, so many comments, etc. I mean, for the arbitrators, deciding on the document production was almost writing an award. So again, sometimes it may be necessary, but the parties should be reasonable because definitely it increases the cost and also the time of the arbitration. Another issue that we should mention, the ethical conduct of arbitration is important. This may include client attorney privilege, and also utilizing the documents without prejudice, utilizing the documents from the settlement, etc. Or sometimes it happens, you know, in document production, the lawyers say we don't have this document, and then during the cross-examination, you cross-examine the witness and they say, yes, I wrote a letter, etc. So then it is really very embarrassing. So as a lawyer, you need to have a very high conduct of ethic, because if the arbitrators may have a wrong impression about you, certainly it may affect on the decision as well. You should convince the arbitrators by your facts, evidence, and also the way you conduct arbitration. Also another issue, training the witnesses or overtraining the witnesses. In some jurisdictions, training the witnesses are completely forbidden. In Turkey, we are more relaxed about it. But in any case, as I told you, the arbitrators are experienced. They were in your place as well. So they know if the witness is overtrained, and even sometimes, unfortunately, witnesses, I observed that when the opposing counsel asked, in your witness statement, you stated this, but now you say this, why? And I said, my lawyer told me so. So this is really very embarrassing. You need to be very careful. You can prepare your witness and you can give some information how the hearing is going to be. This is one thing. But if you are leading or misleading the witness, this is very dangerous. Of course, it would give a very bad impression to the arbitrators. Another delicate issue for the arbitrators is last-minute surprises in the during the hearings. It happens sometimes just before the hearing or at the hearing, one party say, look, we have an evidence we would like to present it, or look, we have a new witness, etc. Or our witness, unfortunately, is not coming, he is very busy, etc. These kind of surprises really may make arbitrators very angry because it really ruin all the schedule, it ruin all the program. And if possible, avoid this kind of last-minute surprises. Of course, if there is any issue, imagine your witness was sick or there is a flight restriction, etc. You can tell about it. But if it is not unforeseeable, unpreventable, then you need to be careful about it because the arbitrators may not be very happy. I hope I did not exceed my time. But if I am right, we are given 30 minutes and we are going to have some time for the questions. So this concludes my speech and thank you very much for your attention and patience. Thank you.
Thank you, Hocam. Thank you very much for a detailed speech. Now it's time for Professor Qureshi and see what he's going to say from the other side of the table as counsel. Professor Khawar Qureshi, QC, specializes in commercial litigation, international arbitration, and international law. He is consistently identified as a leader in his fields of practice and has undertaken arbitrations and litigation for and against commercial and state parties from more than 70 states. He has been from 1999 to 2006. He is one of around 20 panel UK Government Treasury Council, advising as well as representing the UK government ministers and institutions on hundreds of matters. In addition to his practice from Surrey Court in London, in 2008, together with senior members of the English Bar and the retired law lord, the late Lord Slyan of Hadley, he established McNair Chambers, the first ever barristers' chambers outside the UK in Qatar. Professor Qureshi was appointed as a visiting professor in commercial law at London University in 2006. A deputy high court judge in civil law in 2013, a bencher of Middle Temple in 2014, and was the chairman of the UK Legal Services Group from 2010 to 2015. Professor Qureshi, in the past 2 years, in addition to numerous commercial and international arbitrations as lead counsel, he is the only advocate ever to have acted for India, Pakistan, and in high-profile disputes between the two states. He is the first English QC since 1963 to have been authorized to appear in the courts of Kenya in the corruption cases against the Deputy Chief Justice Mivlu. Yes, Professor Qureshi, we have just heard the arbitrator's side, and now we are eagerly waiting for what the council is going to say about. Floor is yours.
Yasin, good afternoon. Professor Akıncı, good afternoon, and to all of our young colleagues at Young ISTAC. It's a great pleasure for me to join you all. I'm sitting, as Yasin mentioned, in the office in Qatar. London is in lockdown until the end of March, when I will go back. And over the past 30 years of my practice, the one point that I will impress upon you as lawyers wanting to argue a case before a judge or an arbitrator is while you're arguing, never pick a fight with the arbitrator, never pick a fight with the judge, and always remember that the decision maker, like the client, is always right. The decision maker is always right. Of course, unless it's necessary to challenge them there and then or appeal afterwards. So your role as a counsel, you've already been told what the arbitrator wants from you, and I would expect you to bear all of that in mind. I'm going to talk from my perspective, having done arbitrations in the Far East, in the Middle East, in Europe, in Switzerland, in Paris, and London, and elsewhere over the past 30 years, as well as court proceedings relating to arbitrations, challenges of arbitrations, and investment treaty arbitrations. So the whole cross-section. And I'm going to deal with 4 issues. Firstly, what do I expect from the institutions? When I say institutions, I don't just mean the arbitral institutions, I also mean the courts. And I'll explain what I mean by the courts. Well, there are courts, when you have an arbitration in a particular jurisdiction, which is called the seat, the courts in the seat have a supervisory jurisdiction. If there's a problem with the arbitration, lack of an arbitrator, there may be some support that the court can provide. You have a supervisory court role. Challenges to the arbitral award can take place there. Then there's the enforcement court, where the award is taken. They're not necessarily the same, as all of you are aware, because of the New York Convention of 1958. Almost every state is a signatory to the New York Convention, which is meant to make enforcement of arbitral awards easier. Some give more weight to the New York Convention in substance than others. So whereas there are some who say they've given complete effect to the UNCITRAL model law and the New York Convention, and the law suggests this, the reality is very different. So after the institutions, I'm going to address the tribunal, what I expect from the tribunal, what I expect from the client, and last but by no means least, what I expect from the lawyers. The other side, often I'm afraid to say, not much, apart from disruption, increasingly because litigation has become very, very, very aggressive, what I expect from my own team and what I expect from the experts. So let's begin with the institutions. ISTAC is an institution that provides support for arbitration effectively, ably, and the fact that you've got this event organized by ISTAC shows to you just how seriously ISTAC takes continuing professional development and making sure that the next generation of lawyers and arbitrators is as aware of best standards as possible. That's a very important aspect of an institution, that it must be dynamic. It must respond to change. When we had the COVID crisis in March, there were many parties that wanted to adjourn the arbitration because for all of us, almost all of us, in-person seemed more comfortable. In-person hearings seemed much more comfortable. For me as an advocate, I can tell you, cross-examining somebody sitting at the other end of a TV screen where they're looking at a small camera is not anywhere near as satisfactory as when they're in the room with the arbitrators, especially if I'm doing it over 10 days, which I've had to do for many witnesses. So the inclination of clients particularly was to try and adjourn everything, use the COVID crisis as a justification. You could, understandably, because they felt that this very important hearing that would be worth millions, hundreds of millions, shouldn't be compromised. Their position shouldn't be compromised because of the failure of the arbitration tribunal to convene. Travel wasn't possible, quarantine maybe was necessary, social distancing. Institutions within weeks emphasized that tribunals had sufficient scope within the powers of case management to be able to allow for online, fully online hearings or hybrid hearings. Same with the courts in England. Within a week of the lockdown on the 21st of March, the Lord Chief Justice, the most senior judge in England, issued a direction, a practice direction, which meant that virtually all cases were dealt with online and still are being dealt with online. So the institution needs to be proactive. The rules need to reflect best standards. There are, in addition to ISTAC, you have the ICC, the International Chamber of Commerce, seated in Paris, but operating all over the world. You have the London Court of International Arbitration, seated in London, but again, operating all over the world. Singapore International Arbitration Center. All these three institutions rapidly responded to the COVID crisis. all three institutions, their rules bear remarkable similarity in terms of what is expected from the party bringing the claim, what is expected from the party responding to the claim, what is expected from the arbitrators. So when you're identifying the institution or a client comes to you for advice, hopefully the contract is clear and it identifies whether or not arbitration has been chosen. And hopefully when you're looking at the contract, you're also familiarizing yourself with the institutional rules, maybe the ethos of the institution, the cultural climate of the institution, because the institutions are different. Necessarily, they're different. Whilst they're international, you may find there is a difference in approach, slight difference in approach between the London Centre for Court of International Arbitration, LCIA, and the ICC, International Chamber of Commerce. It's a very slight difference. You would want to, of course, as soon as your client comes, before you even get to the institution, understand the case properly and maybe try and avoid arbitration. We're talking about what counsel expects from the process, but ideally, you want to be in a position to give your client the best commercial advice. So you've checked, you've understood the institution. The institutional rules are not dissimilar, not so different from other institutions. And then beyond the rules, what's the reputation of the institution? What kind of support do they provide for arbitration? Is the secretariat of the institution slow or fast? There is one institution, world renowned, where there's one particular office of the institution which is much faster than the others. I'm not going to say which one, but over my 30-year experience, I can see that they respond much more quickly to communications from the parties than elsewhere. What kind of review does the institution provide in terms of the awards produced by the arbitrators? Does it provide reviews? Does it have internal mechanisms for challenge of the arbitral process? What is the fee structure? What is the process for appointment of an arbitrator? You must familiarize yourself with all of this before the dispute begins, because the worst situation your client can be in is failure to comply with the institutional rules that it's agreed to through its contract, and then say, oh, I wasn't aware. The rules are available in multiple translations, and so there's no excuse if you're advising a client not to familiarize yourself with the institution's rules. And also the institution's physical location. Where will you be conducting the arbitration? You need to understand from the outset. What is the seat, if it's London, if it's Istanbul, plenty of hotels to go in, no questions about power, no questions about access to photocopying, access to the internet, no questions about safety, security, no questions about coming in and out. Then we turn to the second part of the institutions, the supervisory court, where the seat is. What's the reputation of the supervisory court? Is it going to interfere any possible opportunity? Are you against a local party? And does that mean that when you get into the jurisdiction, you're going to have to be extra, extra careful? How can you avoid that? Have you obtained support, insight from local lawyers? And ordinarily, when I undertake arbitrations, if it's not an English law arbitration, I will always work with a local lawyer. I'd say 80% of my work involves matters which, 70%, forgive me, involves matters which are not English law. And I always work with a local lawyer. And it's important for me, if I'm doing an arbitration in a different jurisdiction, to understand what the institution, the laws are of the supervisory jurisdiction, the local court, as they relate to arbitration, and how they may be triggered. What are the rules of the institution as they relate to confidentiality? What are the rules of the supervisory jurisdiction? For example, in England, there is no express statutory provision for confidentiality of arbitration, but it's developed as a consequence of case law. And that confidentiality is important because you may find your client or your opponent decides to make something public, to embarrass somebody. So what can you do before the supervisory court? What sanctions might be available from the supervisory court? We know that some arbitrators have been the subject of criminal conviction in the supervisory courts. But was that fair? Was that justified? What message does it send? These jurisdictions either had to change their law in the case of Dubai, or have tried to explain why the arbitrators were convicted in the case of Qatar, or arbitrator was convicted in the case of Qatar. But convicting a judge or an arbitrator doesn't necessarily suggest that the process is as free from influence as it could be, unless, of course, the arbitrators behaved extremely badly. So that's the supervisory court. To what extent does it support the process? To what extent does it leave the parties to get on with the process? And to what extent does it interfere? And what is the scope of interference? You must understand this. And then eventually, if you're for the claimant, you are successful and you receive an award, right from the very outset, you should be asking yourself, if I receive an award or my client receives an award 2-3 years down the line, and in investment treaty cases, 5-6 years down the line, where is this award going to be enforced? Where are the assets going to be? Do we know where the assets are now? At the very beginning in England, you can obtain a freezing order over assets, not just for an arbitration in London, but for an arbitration somewhere else in the world, which is an extremely valuable tool from the English courts, because the freezing order is available not to provide security in case you win, but to protect you from the defendant dissipating, shifting their assets around in case you win. And you have to establish to the court there's a real risk of dissipation of the assets. There's a tendency on the part of that party to behave in a certain way for the court to grant you the freezing order. And when it grants you the freezing order, it's very, very powerful. It means that you can continue to proceed with the arbitration or court hearing, knowing that there is some fund which you can address when you come to enforcement, execution. So if at the very outset, your client is coming to you with a dispute and you've ticked the institution, you've ticked the supervisory court, but then you're not sure about whether the enforcement measures in the place where you believe there are lots of assets, because you should have asked the client to work out where's the asset pool. Eventually, can we obtain execution against that asset pool? Can we obtain a freezing order at the outset? You don't want 2, 3, 4 years down the line to find that you have a handsome award for hundreds of millions of dollars, but actually no assets, nowhere to enforce, ideally, from the client's perspective. So that's the institution ticked off. Next, turn to the tribunal. Now, what are you looking for from the tribunal? The touchstone in all institutions and their rules is independence and impartiality. Independence and impartiality. I would add expertise, credibility. Independence and impartiality is vital. This is an increasing problem now, so far as arbitral tribunals are concerned, because you have the arbitrator who is being appointed in ICSID cases, which are investment treaty cases, taking place through the International Convention for the Settlement of Investment Disputes, a convention of 1966. The headquarters of ICSID are in Washington, but these hearings take place in many other jurisdictions. I've undertaken them in Europe. ICSID arbitrations tend to take much longer than commercial arbitrations because there are different phases. Because the state's involved, unfortunately, the level of challenges has increased, and the attacks on arbitrators are becoming much more aggressive. And very recently, we had attacks on an arbitration involving Germany by the claimant Vattenfall concerning an energy charter treaty dispute, all about subsidies in the solar sector, solar power generation sector. The challenge took place because two of the arbitrators, one of whom I know very well, former judge of the International Court of Justice, attended a mock arbitration 3 years prior to the challenge, conducted or hosted by the claimant's lawyers. They attended it, and they attended a reception. And the argument was, having attended that mock arbitration, mock moot and mock arbitration, and having attended a reception, that they ought to recuse themselves. Of course, what that tells you is just how much investigation parties are engaging in now, because so much information is available online. So independence and impartiality, the arbitrators have to be scrupulously careful to protect their reputations and to uphold independence and impartiality. It is an increasing problem because now we're having arbitrators being appointed by a state and only by a state, or by a claimant and only by a claimant. And there has to come a point where this must be tackled. The institutions are very reluctant to allow for recusal, removal of an arbitrator, because then they take the view that if we don't protect the process and stand firm, once challenges start to arbitrators, the level of hostility and the frequency of challenge will just increase. So when it comes to the tribunal, independence and impartiality. If you're going to challenge the arbitral tribunal, think extremely carefully about whether you're going to do it. Not just because you don't like the way they look at you. There's got to be a basis for this. You must at all times try and maintain a professional attitude towards the institutions, towards the tribunal, towards your client, as Professor Akıncı pointed out, towards the lawyers, even your opponents. Because your opponent may take the view that tactically it's better for him to annoy you, because then to personalize it. It's happened to me at the very beginning of my practice. There were people 20, 30 years older than me in my first year of practice, QCs, who thought that they were going to bully me on very big cases. And to use, it sounds awful, but I'm telling you as young practitioners, to use their reputation and presence, as they were extremely well known, and one of them became a minister, in fact, to try and bully in the first year of my practice on very big cases. And I stood my ground. I didn't respond except to continue, to pursue, to succeed. And then maybe from their point of view, this was unnecessary, to say to them that I didn't respond to you outside court because the place to respond was inside court. And that's what I did, and that's what you must do. When it's an arbitral tribunal or a court, your fight is in the court. Your fight is in the arbitral tribunal, not outside, not through 5 letters a day. And you must be very careful not to be baited by this tendency, which is being engaged in, I'm sorry to say, by some law firms, increasingly. Why do they do it? 1, to show their client they're fighting wrongly. 2, to create this tension, which they believe they can exploit because you become angry and you're unsettled. You can't think strategically. And 3, I'm sorry to say, to generate more money. Of course, they're not charities, and these law firms bill on the basis of the units, and the more letters they send, the more they bill. So, independent, impartial tribunal, vital. When you're asked to choose an arbitrator or to recommend an arbitrator to your client, just be mindful of the fact that the arbitrator must be independent and impartial, must be credible, must be an expert who is going to contribute to the deliberations of the tribunal, not just your best friend or the chairman of chairman's best friend who plays golf with him. That's not going to do, because it will be obvious that this person is not independent, is not impartial, or a lawyer who knows about the law of, let's say, China on a dispute that's an English law dispute. What value will this person bring? None whatsoever. The purpose of appointing an arbitrator is so that they can function effectively in the deliberations. Be empathetic, but not biased. So they have some empathy with you, but they are open-minded enough to disagree with you so as to ensure that the tribunal's decision is arrived at fairly. And this is extremely important, as Professor Akıncı pointed out. Fairness must be the focus of the arbitral tribunal. And ultimately, of course, your objective is to win. But you're not going to win by putting somebody on the tribunal who you believe will be the advocate on the inside. Because I can promise you, such a person will be identified within minutes by the other two, and they will just not take them seriously. So that's your party-appointed arbitrator, and make sure you comply with the requirements of the institution, because if you don't, and you miss the deadline, they will appoint somebody for you. And that may be to your disadvantage. Likewise, the chairman of the arbitral tribunal is the person who directs the process, chairman, chairwoman. Ideally, we want more balance in terms of ethnicity, background, gender on the arbitral tribunal, and events such as this, hosted by ISTAC, are part and parcel of the process of ensuring that change. So we have more balance, people from different parts of the world participating in the arbitral process to properly represent the fact that arbitration is international. More women, more young people participating. It's completely wrong from my point of view that the vast majority of those who participate in arbitration tend to be from North America, North Europe, whereas the vast majority of as counsel and as arbitrators, whereas the vast majority of the parties are from elsewhere. This is a complete imbalance which has to change. The chairperson ought to be appointed on the basis of their ability to be proactive, to move the matter forwards. And that's what you want from the tribunal, ideally. Of course, unfortunately, in every process, one party wants it to go slow to avoid the eventual outcome. One person is confident enough, they want it to go fast. And so one will play every trick in the book to slow it down, not realizing that they will annoy the tribunal. And the last thing you want to do is create prejudice in anybody's mind. Arbitrators are human beings. If you behave badly even once, don't believe for a second that they will not have seen it and it will not affect their judgment. Of course it will. And so it's not worth risking it. Challenging an arbitrator and failing means that in their minds you've created hostility, even if they pretend because they're smiling with you and they make an extra point of talking to you afterwards. You have created hostility for no reason. You created tension. And if you're aggressive, likewise, you will create tension. It's just totally unnecessary. They may say nothing to each other, may say nothing to you because they don't want to give you an excuse to challenge them. But what's going on in their heads, you can't tell. So always behave decently, properly. Doesn't matter what provocation of the other side. And expect from them to move the process along fairly. Be realistic in your time estimates. Be realistic in accepting the timelines for the procedure. And be open to suggestions from the tribunal. Don't be rigid. Be realistic. Don't be rigid. Then your client, quite often, unfortunately, the client is the source of many difficulties. The client, for whatever reason, because the client feels they know it all and they don't trust their lawyers, or they only want to tell you little bits, unfortunately, the client is their own worst enemy. Because they will tell you what they believe you need to know to push their case effectively. And if that's all you need to know, well, then they may as well argue the case themselves. It's not much point going to a lawyer if they've decided what is relevant and what is not. And sadly, in some cultures, in some countries, this is much more common than others, without identifying which ones. In others, they'll dump all of the papers on you and they will gladly pay for you to review them because they know what's the point of me going to an expert if I'm going to decide what the expert is going to look at. Well, I go to a doctor for the doctor to tell me what's wrong with me. I don't diagnose myself. So if I'm going to go to a lawyer, I may as well tell the lawyer everything so the lawyer can help me. Should be the approach of the more sophisticated client. The less sophisticated client, you can soon see, you have to give them realistic expectations. Don't raise their expectations. Don't say, this will all be over in 6 months, or of course we're going to win, or don't worry, this witness will be superb, because you must be utterly realistic, because otherwise, one thing the clients don't do is forget. They will complain about fees. They will complain about timelines you gave them. They will complain about the number of reminders you send them the documents. So you must judge the process and your ability to participate in the process based upon the cooperation of your client. That means right at the very beginning, you have to set out what you expect from them, which is fairly expeditious response, openness from them. You expect them to understand that there will be fights, depending on how hostile the other side is. You need to show them the route map. You need them to come along with you in the journey and not just give them completely wrong view, distorted view of what the process is, what the role of the arbitrators is, what is going to happen, what is expected from them, how aggressive the other side may be. That's your job as the lawyer to tell your client. And lastly, the lawyers. And I start with my opponents because disappointingly over the past 10 years, as I've said to you, unfortunately, the climate in arbitration has become even more aggressive than sometimes in court. Why? Well, at least in court, it's open. And at least in court, the bar council can monitor. But in an arbitration in a nice 5-star hotel, where the lawyer can behave whichever way they want, like a cowboy in the Wild West, sometimes provoking the arbitrators. In fact, sometimes deliberately behaving in a bad way, in the hope that someone will say something which is on the transcript and say, right, okay, now, if we lose, we'll just challenge them for bias because they just had an outburst against me. No one's going to see what I did. All they're going to see is what the arbitrator said. That may require superhuman qualities from the arbitrators, but unfortunately, there are lawyers like that. And the best approach for you is to be super careful when you're against such a lawyer. I've unfortunately encountered them, and they will play very dirty, attack the lawyer on the other side, whether it's in court or arbitration, do anything and everything to win. And sometimes you can be caught unawares, but you have to spot them and be vigilant. Experts, your own experts, you must expect them to bring their expertise to the table. You must help them focus their expertise, and you must ensure that they prepare properly for the arbitral process so that they can assist the tribunal. That's your responsibility. If the expert turns up without having read their expert's report, without having read the other side's expert's report, or goes into an expert meeting without really thinking of what the differences are between his or her report and their opponent's report, well, then you're asking for trouble. Because very often the arbitrators will want the experts to meet, to try and settle their differences, to agree what's outstanding between them. And it's your job to guide the expert, because the expert's not the lawyer. The expert should be aware, some of them are, of what the arbitral process is, but don't assume that. So be familiar with what's required of the expert. Be familiar with what may happen when it comes to delivery of an expert's report. Understand that everything that you file before the arbitrators is supposed to help them make the decision. So guide them. You must guide them as the lawyer so that they come to the outcome that you want, which is obviously, hopefully, the right outcome, and also hopefully the fair outcome. The more you obscure what your arguments are by putting in too many, by not using a structure, by not being clear, by having lengthy documents, the less attractive it is for the arbitrators to read, because they're human beings. Simple, keep it simple, and you will be on the path to success. That's where I wanted to conclude and invite questions, if there are any. Thank you.
Thank you, Professor Qureshi. That was really nice to hear what you experienced. Now it's time for the questions. Professor Akıncı, as arbitrator, you must have experienced many counsel from different jurisdictions. Which nationalities were the tough ones, tough counsels, and in what respect they were really tough and why?
Well, I wouldn't qualify it as tough, but I had different experiences from different jurisdictions, I have to say. For example, I was talking about experts, appointing an expert. In one case, I remember there was too many technical issues, and the claimant did not appoint an expert. And then we were three of us from civil law jurisdiction. We said, okay, the claimant did not present any expert opinion, but then as arbitrator, we should appoint expert. That was what we deliberated before the hearing. And at the hearing, when we say we are intended to appoint an arbitrator, okay, let me pronounce the nationality. The colleagues, the lawyers from US, they objected really, very, I'm not going to say aggressively, but let's say they really shocked. They say, how come you can appoint, you can discuss about appointing an expert, because it is the claimant who should prove the case. And now they fail to do this. They fail to present an expert report, and now you even discuss appointment of an expert as arbitrator. So that was an interesting reaction that we were not expecting as tribunal, but in fact it had point. So maybe it is a good experience for Turkish practitioners who are used to expert being appointed by the court or arbitrator. So it is definitely different. And in another interesting arbitration, I remember in one of the arbitration, we started the hearing and we gave the word for the opening statement. And again, they were lawyers from US. Behind their chair, each of them had word, I think maybe 5 or 6. It was the provision that they rely. And as soon as they were given the word, they lift this word like a scoreboard, and then we saw the provision. They said, our case is so clear. The parties agreed and it is in the contract. There is nothing to discuss. So that was a little bit risky, but expressive way to make their point. So it depends. I mean, Turkish lawyers are sometimes very tough as well. I have to say, sometimes when they are angry, you can understand. But generally speaking, civil law fellows, they have a relatively traditional and conservative style. Whereas in the common law jurisdictions, because they are very much used to long pleadings, cross-examination, so their style may be more, let's say, lively and sometimes, if you like, tougher. It is difficult to generalize the jurisdiction. It depends on the personality and style of the lawyer. But I can say, because the civil common law practitioners have very interesting experiences, sometimes they may be also very tough on witnesses as well when they cross-examine. But also they do it very professionally, I have to say.
Thank you, Hocam. Professor Qureshi, how is an arbitrator supposed to suppress or forget his common law education and practice background in a civil law governed arbitration, especially for document production and witness examination phases, vice versa, civil and common law? Çağrı Kurbal asked for this question.
Firstly, I understand this is a question from somebody in Doha, so hello. You may be sitting in a tower not very far from me, so I hope you're well. The simple answer is this: don't approach international arbitration if you're going to be blinkered, because you will be a discredit to international arbitration. Now, I've explained I've done work in 70 jurisdictions or more, from Africa, South America, Central Europe, Eastern Europe, South Asia, elsewhere. For me as a lawyer, even now after 30 years with my hair having gone gray, it's always fascinating to understand, try and understand the foreign legal system, to meet with local lawyers, local judges, experts, appear in the courts. You mentioned I was doing this case in Kenya. It's fascinating for me, hard work. I have 11 lawyers against me, hard work, but still I'm interested in understanding another legal system based upon the English legal system, using English language, but an approach of the courts, which is different from ours, maybe because of the issues involved, because it's an acting Chief Justice who's being charged with corruption, maybe, I don't know. But ultimately, when you are dealing with arbitration, international arbitration, you have to have an open mind and have regard to the institutional rules. And then your experience. If you start sitting as an arbitrator, you ought to have some experience. And you ought to have experience of civil law and common law interaction. The common law is obviously principles based, and our system, the English legal system, tends to be much more focused upon the rigidity of rules. That's the difference in simple terms. But ultimately, the objective is the same, to do justice. So don't be too distracted by this common law, civil law distinction. The bigger problem, if I can say so, and I hope I won't be shot for saying it, is when we have retired judges sitting as arbitrators. That's the bigger problem. Because retired judges generally have not engaged as counsel for 20 years or so. They have cases prepared, put before them. The last time they did a document production exercise was possibly when typewriters were used. I'm being unfair. But certainly in the past, when their understanding of the process is likely to be very different from that of a person who's a lawyer and sitting as an arbitrator. But the point is a good one, it's a very important one, is you can actually see the background of somebody in the approach that they adopt. As Professor Akıncı pointed out, if you've got a lawyer, practicing lawyer sitting as an arbitrator, they know all the tricks. If you have a judge, then a judge, especially a common law judge, likes to take control of the process. Very, very, very strict control. Whereas a civil law judge who is not familiar with the adversarial process maybe tends to be less hands-on. But for you as an arbitrator, it's not acceptable to take with you your mindset of a common law lawyer or a civil law lawyer. You have to really try very hard to dispel that, to take that out, and be focused on the rules. Hope that helps.
Thank you, Professor Qureshi. Another question is from Zora Kızılyürek. Hocam, Ziya Hocam, what is the effects of different ways of evidence collection in civil and common law systems in arbitration process?
Thank you. Well, in a nutshell, there is a different tradition in civil law and common law practice, but in arbitration, we sort of put them together. As civil lawyer, we import some of the methods that we don't use in civil law practice very often. And for the civil law practitioners, they also sort of reduce their way of getting documents. But in practice, let me summarize as follows. So first of all, in civil law practice, what happens is the counsel gather the documents and then present it to the tribunal or to the court. And also in Turkish law, we have a special provision. If any document is not in your possession, the arbitrator can ask the court to assist the arbitrator to get this document. So this is our traditional way to gather the document. But in common law, there is another very important method, very widely used. It is called document production. And in international arbitration, even for the civil practitioners, this method has been very widely used. That means if you don't have any document, but if you know the opposing party have this document, you can ask the opposing party to present this document. And if not, you can ask the tribunal to order this document. And then if there is such an order, this party has to present this document. Otherwise, there may be some interfere otherwise. So therefore, it is a very efficient way to prove your case. And the document production is accepted in international arbitration. Having said this, sometimes, especially for the small cases or non-complex cases, some people said, look, maybe document production is not necessary because it costs time and money to the parties. Therefore, International Bar Association produced PRAC rules that encourage and allows parties have arbitration without any document production. So it is sort of tradition and agreement of the parties and the arbitrators. But I have to say, in practice, document production is very useful and very widely used by the practitioners. Having said this, in common law countries, especially in the US jurisdiction, there are some other methods such as discovery or deposition, etc. This is very widely utilized in US practice, but in international arbitration, these methods are not very widely used. So we have document production. Mostly discovery or deposition is not used in international arbitration. I hope this answered to your question. Thank you.
Thank you, Hocam. Professor Qureshi, the questions from the same person, Zora Kızılyürek. From what you said, is it important to create a checklist and double check each aspect before starting to the process?
The questioner raises an important issue. At the very beginning of your practice, checklists are useful, very useful. But hopefully, once you've been involved in half a dozen or more arbitrations and you're familiar with them, the need for a checklist becomes less obvious. However, it's a good tool. It's a very good tool if you can create a checklist, an internal checklist for yourself and your team. So if you want to take the time and trouble to create such a document, a template, that can't do you any harm.
Thank you.
Yasin, I hope that answered the question.
Yes, thank you. Thank you. Okay, another question is, Do you think mediation will become a serious competitor for arbitration after Singapore Convention in international arbitration? Both of you questions to both of you. Just a few sentences would be enough.
Professor, after you.
That's very kind of you, Mr. Qureshi. Well, you may know that in Turkey, we are very much interested in mediation and also a combination of the mediation and arbitration that is called MEDAR. That is very important for Turkey because for the participants who are not from our jurisdiction, under Turkish law, referring to mediation before the commercial litigation is compulsory now. So each commercial case has to go to mediation first. So therefore, we are trying to combine mediation and arbitration in our jurisdiction as Istanbul Arbitration Center. And this is a very important project for us. And also we promote mediation for the parties. Obviously, mediation has many advantages for the parties. Can you imagine the dispute can be settled maybe within a half day for a very fast and very low cost procedure? It is an excellent, but then what happens if there is no settlement? Then again, the parties has to go arbitration or litigation. So the beauty and the power of arbitration is there is going to be a binding decision. So the losing party cannot say, okay, I'm not going to enforce it. It has to be enforced. So what you get from the arbitration as a product is final and binding decision. But the beauty of the mediation is if the party is settled, if the mediator can facilitate the settlement, then the parties can have a very fast, very non-expensive resolution of the dispute. Thank you.
Thank you, Hocam. Professor Qureshi, what do you think about?
There has always been a resistance to mediation. Again, I can tell you 20 years ago when the court rules in England changed, mediation was being pushed, which led to a massive decline in litigation. The courts insisted that you had to go to mediation before you went to court. And if you didn't, this would be a consideration for the courts when it came to costs. If you'd avoided mediation unreasonably, and yet you'd won, the court could say, you're not going to get your litigation costs. You should have tried mediation. So this is a powerful tool to persuade people to go to mediation. There are some kinds of disputes that can never be mediated, whether it's too politically sensitive, the emotions are too high, and or because of strategic reasons. But my own view is, if approached with the right mindset, mediation can actually be extremely helpful, especially for businesses, to try and repair damage that may have been caused because of hostility generated by a dispute, and to help them to move forwards in a commercially viable way. Whether or not parties adopt mediation as being realistic to some extent is part of the cultural context. A mediation involving an elder is normal, especially in the Muslim world. It's part and parcel of the Muslim world to try and involve seniors to try and resolve a dispute, but of course not in the commercial context as much as it used to be. Another technique which is extremely valuable and that I've used is what's known as early mutual evaluation. On a confidential basis, the parties appoint a third party, often a retired judge, and they give them the submissions, and then they appear before the judge for a very short period of time. The judge asks some questions, and then the judge delivers a confidential indication based upon what you said about your arguments, based upon what you said about your arguments. And it's about, and you can only do this on points of pure law, generally. Because otherwise, if no, he's wrong, no, he's right. Well, how's the evaluator to decide? And there was one case that I did, which was all about an insurance policy and the consequences for interpretation of a clause the consequences were potentially hundreds of millions of pounds. And if the dispute had been fought out in the public, then there was a knock-on effect for other insurance policies. So our client, which is one of the biggest insurance companies, had an interest in trying to have this resolved without the full glare of publicity with a counterparty. And we appointed a retired Court of Appeal judge who looked at the issues. We made submissions, totally confidential, and gave us an indication, which was very helpful. So don't forget that either. But you need to find an issue which you can both say, this is the issue, this is the clause, there's no fact, this is what we believe it says, this is what they believe it says. The evaluator looks at it and takes a view. I hope that helps.
Thank you. It was very good. Okay, I will ask a question to both of you. In ISTAC, we as the center are really careful with the timing. I can assure you that 95% of our cases finish on time. But we hear about some other centers in which the completion process extends to 2 years or more. Why do you think this has happened over the years? As in your experience as counsel and arbitrator. Professor Qureshi?
Okay, I'll start. As counsel, often the answer is very simply this. When the initial terms of reference have been set, they've been unrealistic. There's not been enough flexibility. First point. Second point, that one of the parties is being disruptive, unfortunately. Third, that the arbitral tribunal is not engaged with the process. It's not actually being proactive. Fourth, availability of the arbitrators. You're insisting on getting them together to make a decision. They've taken on too much. And so to get them together, and then for the convenience of counsel and the convenience of witnesses, when you try and achieve consensus on dates, it's not the same as a court saying, well, I'm listing it for such and such a date. Whether you are available or not in a year's time, you can't tell me, oh, I may have to go to the dentist in a year's time, I'm not sure. So do you mind? But in arbitration, I'm not saying excuses, but the ability of parties to extend is far greater than it is in court. So those are the main factors from my point of view.
Yes. Thank you. Thanks. Hocam, what do you think?
Thank you. I fully agree. Maybe I can analyze it in two different ways. The first one is Mr. Qureshi correctly stated that the availability is the key issue, not only the arbitrators, but also lawyers' availability. I would divide these issues into two parts. Practically until the hearing, the timing is on the hand of the counsels, because at the end of the day, the counsels are going to draft the submissions, collect all the evidences, get the expert reports and then witnesses, and then reply, etc. So it is the counsel's duty and counsel's timing. Imagine as an arbitrator, if the claimant is asking 6 months to draft their statement of claim, I mean, you cannot do anything. You are going to give another 6 months to the respondent and then reply. Suddenly, you are going to spend more than 1 year on the exchange of the submissions. So therefore, it is very important that the counsels are available and they are fast enough if they want to have a fast decision. But after the hearing, mostly it is at the hand of the arbitrators to keep the time, because after the hearing, there is going to be, if there is a post-hearing brief, and then the arbitrators are going to deliberate and draft the award. So practically, after this, the timing is in the hand of the arbitrators. I experienced some very famous, world-famous arbitrators. It took more than 1 year, 1.5 years just to draft the arbitrators, especially if the chairman is very busy. You know, everything is finished, and then the chairman give you the appointment for deliberation more than 1 year after. You even forget the case, you even forget the counsel. So sometimes it is very important that the arbitrator that you are going to nominate is available. You need to make sure. So therefore, both counsel and arbitrator may cause the arbitration delay. And on the other hand, the opposite is also, of course, true. If the counsel, before accepting the case, make sure that the counsel and the team is available for the case, and also when the arbitrator check it is available for the case, then they can have a very efficient arbitration. So therefore, my humble experience is with the institution, generally, the time for arbitration is very well disciplined. Even the same arbitrators, when they act as an arbitrator for the institute, they are very careful about it because they may have a reputation that this arbitrator is slow or not available. But if it is especially an ad hoc arbitration, you need to be very careful because the arbitrator may put this case at the end of its list because it knows the institutes is being monitored, the arbitrator's performance. So you need to be even more careful if your case is an ad hoc arbitration. Thank you.
Thank you, Hocam. Now we have come to the end of our program, but one last question. I just wonder, if you are asked to choose one of them, which one do you prefer and why? Arbitrator or counsel? Hocam?
Well, let me tell the truth. Before starting the hearing, I always say I'm not going to be a counsel anymore. I'm going to act as an arbitrator because it is so stressful, so tiring, so many sleepless nights. Enough is enough. I promised myself, I said, okay, from now on, I will act as an arbitrator only. But as soon as the arbitration finishes, you know, you have a nice meal with your team, and then you have so many war stories because it is so exciting, it is so motivating. I think acting as a counsel is really very special. I mean, full of excitement each point. But then acting as an arbitrator, you see everything from the top, and then I mean, it is also very nice. My point would be acting as a counsel is very tiring, but very pleasant, full of satisfaction. But maybe the award of this, when you are experienced, then you get quite a good number of appointments. This is also a big honor.
Thank you, Hocam. Okay, Professor Qureshi.
Those are very wise words from Professor Akıncı in terms of the transition from counsel to arbitrator. There are always some people who much prefer being counsel to arbitrator, I being the one who's advocating, arguing. Before we went live, we had a discussion about a judge in England, I'm not going to name who he was, who had a reputation for still being the third advocate in the room, sitting on the bench and telling the parties what their arguments could be, should be, what the responses could be, should be, which was great. You just felt, well, what am I doing here? The judge is doing the job for us. So a completely different mindset is required. And as counsel, of course, you have to anticipate the weaknesses in your argument. As arbitrator, you have to be open to listen, to be capable of being persuaded. So there's a slight difference. Anticipate weaknesses in your argument, be open-minded, capable of being persuaded. Maybe two sides of the same coin, but an arbitrator needs to be much, much more patient than a counsel, because the counsel's job is to deliver his or her case as effectively and as efficiently, as politely and as professionally as possible. And the arbitrator's then got to digest it and come out with a conclusion. So it really is about your personality more than anything else.
Thank you, Professor Qureshi. Okay, the attendees thanking you all. Now we have come to the end of the program. Thank you to both arbitration experts, Professor Akıncı and Professor Qureshi, for their detailed sharings and answers to the questions. And also, I would like to thank all the attendees for their patiently listening to the program and following the program. And I hope to see you all in another event. And take care for now. See you, Professor Qureshi. Take care.
Thank you, everybody, and hopefully see you in person in Istanbul in the not too distant future.
Yes.
Take care.
Bye-bye.
Goodbye. Goodbye.